Hello and welcome to this presentation on making an application for permanent residence. This presentation presupposes that you have acquired the right to permanent residence already, but if you're unsure about that, it would be wise to research your position thoroughly and potentially seek independent, qualified advice. Please note that the Home Office frequently makes changes to forms, fees and other details concerning procedure. The information in this presentation is correct at the time of recording, which is 15th of November 2016. Before going further, I recommend that you have in front of you a copy of the application form, which is called EEA-PR, and the guidance notes, and both are available at the link on your screen. The focus of this presentation is on making a paper-based application rather than the online option. Those that attended the face-to-face sessions may recall that the online option may be particularly important for those of you who travel regularly and need to retain your passport. You will have noticed that the EEA-PR form is 85 pages long, which is nearly 7 times the length of the previous form, which was called EEA-3. The Home Office's guidance specifically states that the EEA-PR form is not mandatory. Therefore, you could, if you wish, choose to use the older, shorter form, or in theory at least no form at all, providing that you submit the requisite evidence. If you decide against using the EEA-PR form, then it would be wise to cite this section from the guidance in your covering letter. Whichever method you choose, you must ensure that you pay the correct fee, which is £65 per applicant, and if you are a non-EEA national, you must provide your biometric details. Do note, however, that the guidance specifically states that it will assist the Home Office in dealing with the application more efficiently if the EEA-PR form is used. Changes brought about by the EEA Regulations 2016 means that from 1st of February 2017, all applications must be made either online or on a specified form. In other words, those hoping to make applications using the old forms, or even no form at all, must do so before 1st of February 2017, or the application will be invalid. The EEA-PR form is clear in terms of the information you need to provide in order to make payment and provide biometric information. Generally speaking, there won't be any need to consult the Home Office's guidance. The only point to emphasise is that if you are an EEA national, you do not need to provide your biometric details. Sections 1 and 2 concern applicant and sponsor details. If you have already completed the biometric section, then you will find this section repetitive, but you must still complete it nevertheless. The definition of the term sponsor can be found on page 20 of the EEA-PR form itself. If you are applying as a family member of an EEA national, or in certain limited circumstances the family member of a British citizen, then that person is your sponsor. I won't dwell on this section because it is relatively self-explanatory. However, I will flag up section 1.21, which requires you to submit a valid passport, travel document or national ID card. Alternative evidence will only be accepted if you can show you are unable to submit these due to circumstances beyond your control. The guidance doesn't elaborate on this, but given that you have the choice of submitting either your passport or national ID card, I would suggest that the need to travel might not be a sufficiently compelling reason. Section 3 is the key to navigating your way through this incredibly long form. Page 24 of the EEA-PR form specifically states that you may choose to print only the sections that are relevant to you. I'm going to skip section 4, which is about replacing or renewing your permanent residence document, as it is not the focus of this presentation. Section 5 contains what will be for many an onerous request for details of all whole-day absences from the UK. This is a feature of the current EEA-PR form, as it was not included with the older EEA-3 form. There is nothing in the guidance that assists with the specific issue of providing dates of absences. However, I would emphasise that there is a world of a difference between deliberately misleading the Home Office, which you must not do and is a criminal offence, and providing details to the best of your knowledge and belief, even if you cannot remember every trip abroad. If you cannot provide all of the information, then a detailed letter explaining any gaps in your knowledge would be wise. Ultimately, the Home Office needs you to evidence 5 years continuous residence. The guidance states that you should provide at least 2 documents for each year of residence, but it cannot be a bad idea to submit more documents if you have them, so that the decision maker can be in no doubt that you have satisfied the residence requirement. The documents should be spread evenly throughout the year, and they should come from a variety of sources. Bank statements, utility bills, telephone bills are all examples of the kind of evidence the Home Office will expect to see. Further examples can be found in the guidance. In Section 3, you will have already established which of Sections 6 to 15 you need to complete. I will focus on Sections 9 and 11, as these are likely to be the most common. However, do check the guidance notes for any of the sections that apply to you. Section 9 relates to your time as a qualified person in the UK. The evidential requirements are set out in the guidance on pages 8 to 10, and they relate to employment, self-employment, temporary incapacity, study or vocational training, students and self-sufficient persons, and those looking for work. For those who are relying on their time in the UK as a worker, the Home Office expects to see a letter from each employer confirming dates, salary, hours, and the reason for leaving. They also expect wage slips and or bank statements showing receipt of wages for each job you have held during the 5-year period, as well as P60s for each year you were employed. The guidance does provide a list of alternative documents if you can't get hold of any of these, but it says you do have to explain why it is that you can't. These appear to be onerous evidential requirements, and certainly the old EEA3 form did not require so many documents. It is hard to see why all of these documents are required, as your P60s, combined with up-to-date wage slips and bank statements, should be enough to evidence your status as a worker. Home Office guidance is not allowed to impose more stringent requirements than the law itself, but on the other hand, it does give you a clear indication of what the decision maker is going to expect. If you are unable to provide all of the documents listed in the guidance, or if for whatever reason you choose not to, then it would be prudent to include a detailed explanation in a covering letter as to how the evidence you have submitted shows that you have been a worker for a continuous period. Section 11 should be completed if you are applying as a spouse, civil partner or durable partner of an EEA national. The evidential requirements are set out in the guidance on pages 11 to 12. The guidance sets out the number of items of correspondence that unmarried partners need to submit in order to evidence that they have lived together. Do note, however, that there is no requirement for unmarried partners to cohabit under the EU directive. So if you are an unmarried couple who do not live together, but nevertheless consider yourselves to be in a durable relationship, don't give up hope. However, you may wish to consider taking independent qualified advice. Generally speaking, in terms of evidence, more is more, and the more you can submit to demonstrate to the decision maker that you have been a qualified person, or the family member of a qualified person, for 5 continuous years, then the more likely your application is to succeed. You cannot get penalised for submitting too much evidence, and so if in doubt, provided it relates to the relevant period, put it in. Section 16 relates to public funds. You must not mislead the Home Office, but in any event this section in many cases will not impact upon the core issue of whether you have been a qualified person or the family member of a qualified person for 5 years. You are not excluded from being considered a worker if you have claimed child benefits, and in the case of a job seeker, the very fact of claiming certain benefits may actually evidence you being a qualified person. By way of observation, however, this section is not included on the older EEA3 form. Section 17 relates to criminal convictions and other issues relating to character. Again, you must answer these truthfully. Unlike applications for naturalisation and various applications under the immigration rules, Criminal convictions often do not preclude permanent residence. If you are in doubt, you may wish to seek independent qualified advice. Section 18 serves as a document checklist and is sensible to complete. You should also refer to Annex A on page 14 of the guidance. Section 19 contains various declarations that need to be signed. That concludes the presentation. I hope you found it useful, and good luck with your applications.